This is Paul. Yeah. I'm just kind of going through this. Again, I don't see any order for hold until the mental health evaluation. Yeah. For some reason, the speedy trial was done away with. The public defender said that I waived my right to a speedy trial, but I didn't. I wanted it explained to me. But they put that on this form, so this is actually wrong. Um, and then it's kind of interesting. That's really my signature for the most part, right there. Now, when you don't fill out court forms the way that they're designed, then the court orders are suspect. Okay. Now this is interesting. I got this request from the public defender's office. Yeah. And well, Judge Porter requests your presence in court, and I said, well, that's real nice and everything, and I'm not trying to evade going to court, but I'm going to actually require to have the notice, the subpoena, or the summons. And they sent me numerous text messages from court that day. Well, you better get your ass down here because the judge is going to want to talk to you. I'm like, no, I'm not going. I'd emailed the police department in Port Angeles, Squim, and I'd emailed the sheriff's department, and I had emailed my public defender, and I had emailed those that have the legal obligation for the enforcement of the law. Now, you would have thought that if they had issued this on September 24th, 2016, September 7th, 2016 at 7:22 a.m. That's probably the day after when that fax went out. The Collin County District Court. It's interesting that if I was such a threat, they had waited 17 days to again get another fax on Saturday at 1:15. Collin County Jail. It looked to me like somebody's been holding warrants instead of actually enforcing them. Now, I'd need to know every warrant from when it was issued to when it was actually served on the person that they arrested. Because let's say you're getting paid for a show and you use some clones as a fictitious perpetrator and a fictitious victim, and you decided you're going to make a show and you're going to teach me a lesson. So you arrest me on January 4th when I wasn't in Squim on December 31st, and then you decided, well, you're going to have a mental health evaluation. You're going to do it when we say, and when you don't do what we say, we're just going to issue a bench warrant. And I'm like, well, I'm happy to explain, not necessarily happy, but I'm willing to explain to Judge Porter that I had nausea, blood nausea that morning. Now, for any judge to put me in jail because they understand that a mental health evaluation means that I should feel good when I do one of those. And since it's not a court hearing, as I understand it, judges can only require a person to have to go to court. They can order a mental health evaluation, but I'm the one that decides when I take the mental health evaluation. Now, I know there are court orders, and I still have not seen a court order for a mental health evaluation. In fact, when I went through these, here's another one: hold until the court reviews a mental health evaluation. And then there's another one over here: hold until the court reviews a mental health evaluation. As the defendant, you would think that I would have to be informed if the court is going to review a mental health evaluation. So you can order me to take one. I can decide when I do that because it has to be done before the next court hearing. I decide because I want to be sure and be healthy on that day and look good. And you get to hold until you're done reviewing the mental health evaluation. Now, I know that if it is found, City of Squim, Collin County, State of Washington, plaintiff versus Paul Budnek, allegedly it was the petitioner that was violated. Did the state of Washington just arbitrarily decide to issue protection orders against fathers or parents without the other parent wanting the order? Well, did the government take over the lives of my 5 sons and has been holding them hostage? Now, if you look here, 6 feet tall, race white, 225, expiration date, so on and so forth, so violation date 12/31/2015. I violated or allegedly violated a protection order on that day when I wasn't there, and the petitioner didn't want the protection order. So really the government decided they're just going to do what? Complaint, original Quinn Police Department, oath or certification description, okay. Bail, warrant, expiration date 2023, case number. Failure to appear. I never failed to appear. They failed to give me notice of court hearing, summons of court hearing. Now, when I'm homeless and the only way to communicate is through the public defender's office, putting me in jail for 27 days, when I had informed the police department. Bond of $10,000 or bail ordered at $1,000. Received on September 27th of 2016. And, oh, wait a second here. It could have been Wednesday, 7/22/2016. I thought that was the day of the court hearing. Now, if I went through my emails, I could find out what times that I thought it was actually September 7th was the day of the court hearing. No, it's September 6th. That's part of request your presence on September 6th. Because I was only given 2 legal judicial days to respond. You know what? It would have been nice if you just removed the protection order and given me my sons. I'm not going to have any time to make any more videos today, but tomorrow's a new day and I could make another 20 or so videos if you think you have any money left.